Hey everyone, it's Julie Kruger from Kruger Immigration Law. You're probably hearing in the news today that President Biden is planning to sign some executive orders on immigration this afternoon at 5 p.m. So I wanted to talk to you a little bit about what's in one of those executive orders, which is about the public charge rule. This is something that affects a lot of our clients, especially our clients who are applying for a marriage-based green card. One of the things that the Trump administration did over the last 4 years was really enhance the public charge rule. And this is the rule that's been in immigration for a very long time that says that immigrants have to prove that they can support themselves in the United States and that they're not going to need government assistance in order to meet their basic daily needs. And in the past, this was always done in a fairly simplified way, showing that the person who is sponsoring them or their petitioner could support them if needed. The Trump administration really enhanced this rule, set up a whole system of 7 or 8 different criteria that they would look at to determine whether or not someone was going to become a public charge, and issued a new form called the Form I-944, Declaration of Self-Sufficiency, which would, the immigrant was required to explain their education history, their English speaking ability, their assets, their debts, whether they've ever used public assistance before, a whole host of things to show whether or not they could be self-sufficient in the United States. So one of the executive orders that President Biden is signing today is to instruct agencies to review this public charge rule, this enhanced public charge rule that President Trump put into place, and determine what to do about it. Honestly, this is something that I think that has been well discussed over the last year and a half or so since that public charge rule, that enhanced rule, was put in place. It's been litigated over and over and over. All of the opinions are out there. I think that directing an agency review is literally the least thing that the Biden administration could do on this issue, and it's too little. So I'm hopeful that that agency review doesn't take a long time, that agencies take a look, make quick decisions, say that this is not a rule that is useful in any way, that the enhanced Form I-944 really puts a burden on applicants, on petitioners, to show that they're not going to become a public charge in the United States, and really that it is not necessarily reflective of someone's ability to support themselves in the United States. So I'm hopeful that the Biden administration does much more than this, that the agencies do move quickly to assess this rule, determine that it has been a burden on petitioners and applicants. It's been a burden on the agencies. It's been a burden on the court system that's trying to litigate all these cases that have been brought on this new rule. So, and then once they have, made their assessment and the agency recommendations, that the Biden administration moves really quickly to actually act on those and make the necessary changes. So that's one of the things that is on the executive order today, reviewing the public charge rule and how whether or not it should be continued. Again, I think that's too little, that more should be done, but hopefully at least this part will move quickly and more things will be done quickly in the future.